I'm going to start with the lender liability watch, a couple of big cases here. This first Thompson case was actually a real estate loan made by the old Bank of Louisville. It went into workout and forbearance, and then it went into foreclosure, and then the borrower sued the bank saying, you defrauded me with your workout and forbearance documents. They didn't say what the bank officer said they said. And later it became clear that he had never read the forbearance agreements, but he was still able to recover a $10 million judgment, which was all over the papers. As usually happens in these things, when the Court of Appeals vacates the judgment, it doesn't make news. You know, the jury verdict makes news, but when the results change, it doesn't seem to have the same public appeal. The reason I mention this case is because it illustrates the importance of strong forbearance language and planning in your workout agreements. The bank's language was very good, and it had releases in there that the Court of Appeals said, you know, borrower, it doesn't matter that you didn't read this document, you're bound by it, you signed it, and you released all the causes of action that were in existence at the time you signed this forbearance agreement. So it's a very, even though it's, you know, it's a couple years old now, but it's a very important case for us in the workout area. Now, this past year we had another huge judgment in another Thompson case in Jefferson Circuit Court. And this is a settlement agent fraud case, and it's, you know, it's a residential refinance. And what happened was that the new lender wired in the money to the escrow account of the settlement agent. The settlement agent was supposed to pay off the prior lender, Wells Fargo, but never did. The settlement agent stole the money, kept the money, and paid the monthly payments in order to keep the fraud from being discovered. Eventually, missed payments and the fraud was discovered. Wells Fargo had released the mortgage before they received the money, which was a mistake, and so they re-recorded their mortgage when the payoff check bounced. And it was about a $200,000, $250,000 mortgage loan, but the jury returned a verdict for $22 million. You know, I don't see how that happened. Obviously, the settlement agent was the primary wrongdoer here, but was insolvent, and so all the banks were sued, and as well as the lawyer that had drafted the mortgage and advised the settlement agent. So this $22 million judgment was all over the newspapers, but there was no coverage when the trial judge vacated the jury verdict. The reason he vacated the jury verdict was he decided that the damages expert was not an expert on damages, and they should never have gotten the $22 million. So the bank, so the judgment against the bank was vacated, and the case will be retried this summer. The judgment, $1 million judgment against the attorney stands, though, and it will likely be appealed. There are a couple of things to take away from this. One is that you should always have a closing protection letter. This is exactly what a closing protection letter is for. It gets the title insurance company to back the settlement agent in case they steal the money. But there was no CPL in this case. The other thing that's interesting to me is I don't understand why Wells Fargo was the one left holding the bag. It was a different bank that hired the settlement agent. It would seem that the bank that dealt with the wrongdoer should have been the one that was left holding the bag. And, you know, sorry, Liz, but all of these plaintiffs are Thompsons. Are they poor credit risks or what? Okay, next is Blaine on contaminated property.
Thanks. Good morning, everyone. Again, Blaine Early from our Lexington office. I am in the environmental group, but I do practice a lot with the creditors' rights. I feel very privileged to be here with my bankruptcy colleagues. There's a surprising number of cross interactions between environmental law and environmental obligations and bankruptcy in particular. Liz said we're going to tell a bunch of scary tales, and yes, I hope to scare you a little bit, but I will promise you that my last topic is a very hopeful tone, so I'm going to leave you smiling, at least I hope, this morning. First off, CERCLA or Superfund, this is a very mature federal statute. I'm sure that you all are familiar with some of the basics of it, but there are a couple of things I want to point out in some recent developments. This is intended to fund cleanup of areas where hazardous materials have been released to the environment, and it's a strict liability statute. The owner or operator has liability regardless of fault. If you find nasty stuff on your property, the owner or operator is liable for that. Now, by statute, the term owner or operator doesn't include somebody who holds mere indicia of ownership. In other words, your security interest in the property. So, as long as a lender doesn't actively participate in management of the facility, and you only hold the security interest and you act protecting that interest, you're okay. There are a lot of things you can do. You can require in your loan documents compliance with law. You can loan funds specifically for a cleanup operation. You don't want to be there directing activities on the ground. You don't want to be part of that business saying, no, don't ship that to the hazardous waste facility, just go dump it over in the Ohio River. It'll be okay. You don't, of course you're not going to say that, but there are some surprising criminal cases where people have done something just as crazy. But again, as long as you're holding the security interest to protect your investment, you're fine. If you move to foreclose on the property, which sometimes you have to do. Sometimes the best forbearance agreements don't work, and the best laid plans of, well, give us another 6 months. This is going to turn around. We'll pay you in full. Sometimes those don't go right, and you have to foreclose. If the lender forecloses on that interest and then moves rapidly to just protect the property and then sell it expediently, then again, that's not actively participating in the management. But you don't want to be stuck in a situation where you're holding on to the property longer than you anticipated, and the lender then becomes sort of the default operator or manager of the property. Now let's talk just a second about the...
Blaine, I think we have a question.
Oh.
On that point, if the lender has a controlled entity purchase at the foreclosure, does that controlled entity enjoy the same protections with the lender?
That's exactly where I was going with it. So yes, that's a great question, and that's often the approach, is to have a special purpose entity that's related to the lender. And you said a controlled entity, so you mean like a subsidiary or a sister company. And the U.S. Supreme Court in the Best Foods case clearly decided that those kinds of protections that are part of traditional corporate law, the limitation of liability, just for that corporate entity, that those apply even in these environmental statutes. So the answer to your question is, for this special purpose entity, if that special purpose entity takes ownership, then that will protect the lender as long as the special purpose entity and the officers and directors of that special purpose entity act like they are part of that entity and not the parent. The Best Foods case and cases since that have looked at the situation where you might have situations where the parent company and the subsidiaries often share a number of staff members. Maybe they have the same presidents or common directors. And so the questions then become, as that special purpose entity operates the facility, are those people, are those officers, are those controllers, are they wearing their subsidiary hat, or are they really wearing the hat of the parent president acting through the subsidiary? So it's not an easy question. It's a very, very fact-intensive question as to what roles the people who are making the decisions are playing. Are they really acting separately in their corporate nature, simply as actors on behalf of the subsidiary, or are they acting more as officers of the parent? Does that answer your question? Okay. But before you go to foreclosure, you need to be aware of, in particular in Kentucky, for those of you who are Kentucky operators, the Kentucky Superfund statute has a wrinkle that's different from the federal, and that is that before the foreclosure, there has to be really essentially a clean environmental site assessment. You can't go into this foreclosure and buy property in foreclosure if you have any reason to know or if you have any knowledge of contamination on the site. Now, that's a little bit more draconian than the bona fide prospective purchaser in the federal statute. But the takeaway from here, the question about best foods and operations, that's one thing. The takeaway from this aspect, if you're going to foreclose, to gain the maximum protection, make sure that you have updated a Phase 1 environmental site assessment no more than 180 days before that purchase, before the foreclosure. And that will put you in the best position. It's not a fail-safe, because you may have something like this Kentucky statute, but you will not be able to raise that innocent purchaser, if you will, defense, or the mere foreclosure defense if you haven't had that recent Phase 1 done.
And I'm Brian Pollock, and I'm in the Louisville office. I'm the third Brian in the Creditors' Rights Group. You just call for a Brian and you'll get someone who should answer a question for you. I'm going to talk a little bit about participation agreements and some of the litigation risks that are showing up now. When you start with a two-page document that's not been revised for 20, 30 years and is just sort of put out there between two banks that are getting along right now, until that underlying loan goes south, it's not an issue. But when it does, then people start to look at what's actually in that participation agreement. What did I cover in the agreement between the two banks? The purposes for participation agreements, the reason banks do these participations, it lets you get a larger loan. You don't have to worry. You can get around the lending limits. You don't have to carry the entire asset for the whole bank. A participant bank, it's an opportunity for them to get into a different market. It's an ability for them to participate in a larger loan and be able to say, I'm making this $10 million loan here, and be able to advertise that as something that you're capable of doing. But then when that underlying loan defaults, and then the interests of the two parties diverge. You've got the originating lender who's got their client that they've been working with many years, and they want to work with that borrower. They want to work through this. They want to get the work out. They want to keep the relationship. And then you've got the participant bank whose mindset is, well, all I've got involved here is money. I don't have a relationship with that borrower. I want my money. I want aggressive collective action to be taken. I want you to foreclose right away. We don't want it to go through a slow workout and let my collateral deteriorate here. And when those interests diverge, then you look at the participation agreement to see what are the requirements there. And some things that have come up in recent litigation is disclosure. What are your obligations under the agreement? What do you need to know? What do you want to know when you enter into a loan agreement? The lead bank should be concerned with the scope of the information. How much information do I have to provide to this participant bank? How quickly do I have to provide that information? And when they're providing that information, it's keeping the detailed records of the information that you've provided to the participant banks so that they don't later come back and say, well, you never told me that you all downgraded this loan. We initiated the loan and then you downgraded it 2 categories, and at that point, if I had known about that, I would have wanted you to foreclose. And you need to document the facts that you've told them about this. The case law, when you've not told them about an internal downgrade, something that doesn't really seem to have a great impact on the borrower's actual ability to pay. It doesn't actually change the borrower's ability to pay. That's more of an internal note that you've put in there. But courts have held that to be a breach of the participation agreement and a breach of the disclosure requirement. So some ways around that: have periodic memos going out to all of the parties, conference calls discussing the loans. And that gets into what you should consult and talk about in these conference calls. Some of the things that go into a participation give you the additional duties and whether you have to consult on certain issues. What types of things would you want to be consulted on if you're a participant bank? Would you want to be consulted on extending the maturity, a reduction in the principal balance, whether they release the guarantors or release the collateral involved? All of these things that should be included in this participation agreement that you've not looked at, that you just sort of put out there, that 2-page document. This document that's been around for 30 years requiring that your disclosure and your consultation go out by telex as opposed to fax or email or a more modern form of written communication. And then the question becomes, who makes the decisions? Who has control over the decision when the originating bank is saying, we need to work this out? The participant bank is saying, no, we need to foreclose right away. There was a case where the language in it was that if the parties can't agree on the action, the lead bank can foreclose and take any other action. They had a consultation, they talked about it, the participant bank wanted them to foreclose, they weren't ready for that. They went and worked out the loan, but because it was foreclosed and take any other action, their unfettered discretion to do what the lead bank to do whatever they wanted didn't arise until they actually foreclosed. So while they eventually worked out the loan, if they had foreclosed first and then worked out the loan, that would have been acceptable in the court's view. But because they had skipped the foreclosure step and not met that and, they had violated the participation agreement. The documentation that you look at and when you have to produce it on request, this can be more than just the loan documents. Here you're also going to end up having to think about, what about my internal emails, the memos that I have going around, things that you may say between the loan officers, the asset manager on it, deciding what to do with this. If you think about that, that also ends up going to the participant bank out there. And you need to look at how these documents, what documents are included in there, how you produce these documents. And you may also think about this from the lead bank perspective as this is a means of informal discovery. The participant bank, once they are realizing this loan's going south, they're going to start looking for something that the lead bank didn't disclose. And they're going to look at what documents can I get them to turn over, what documents were they required to produce, ask them to get those documents over to you, and you've now developed your case as the participant bank against the lead bank. Another issue that comes up often with participation agreements are the administration standards. They'll often have language in there about administer, hold, and collect on the loan with the care of a prudent man under the circumstances. Well, the banks certainly are going to disagree on what the prudent man is going to do. The participant bank thinks that a foreclosure was the prudent thing to do right away. The lead bank thinks that it was a workout was the best option at that point. And so you have the issue of, well, with a prudent man and you've got a reasonable standard and you've now got a fact issue and you're going to be litigating that issue just because you didn't clearly state what the administration standards. The other parts that can be part of your administration standards talk about the due diligence that each party has to do. The participant bank may not look at it as we're making a credit decision here, we're deciding to loan to this borrower, and instead maybe relying on the lead bank's credit determination for the borrower? Should the lead bank have something in there requiring independent verification of the creditworthiness of the borrower? Make the participant bank do a little more than just rely on the lead bank to be another guarantor, an unofficial guarantor of the collectability of this loan. One of the issues that also comes up is tort liability, because as soon as we start litigating between a participant and a lead bank, they start talking about fiduciary duties between the parties. And you would think with an arm's length transaction, two large banks making decisions on a loan, they're ably represented and they know what they're doing, they're in this business, it would be hard to see that there would be a fiduciary duty between the parties. But that's usually one of the many claims in these participation litigation, is they were a fiduciary and they breached the fiduciary duty to me and get the tort liability for that breach of the fiduciary duty. So in drafting these, make sure to avoid any suggestion of a fiduciary duty. Make it clear that this is the arm's length transaction. And for any additional tort liability, it's got to be a duty beyond the contract. Tort liability, it's not just simply a breach of disclosure. Say you've got a disclosure requirement. Well, a failure to disclose, a fraud by omission, by failing to disclose, would the fact that you've got the contract, that should prevent it from being, you breached your duty to disclose, you breached your contractual obligation to disclose, but you'll be fighting over whether or not you breached a common law duty of disclosure and have potential tort liability there. So the main area is the breach of contract. And so we said with that case where they failed to disclose the internal downgrade, that was a breach of contract. But then the question becomes, so what? I breached the contract. I didn't tell you that it was internally downgraded. What does that matter? How were you damaged by that? And so you look into these agreements, and you've got it very difficult to calculate the damages there. So some participation agreements, participant banks want a buyback provision or a repurchase requirement. Say you failed to make these disclosures, well, you breached the agreement, give me all my money back that I participated in this loan. And now this credit that you were carrying and only had 10% on, all of a sudden you're back with 100% of the liability from it. And so a question comes up in these participation agreements, do you include a damages provision? And a final issue that has shown up with participation agreements with a lot of the bank failures in the last few years is, well, you've got a good relationship with the bank that you joined in with this participation agreement, and then all of a sudden they enter into receivership, the FDIC takes over, they sell the bank, and you've got a new party on the other side. And so you look into the participation agreement. Do you have a limitation on assignment of this? Is consent required? Do you put something in there about it being a personal services contract? Make sure that you talk about the trust and confidence that the parties have in each other. But then you start talking about trust and confidence, are we getting into a fiduciary relationship between the parties? So you have that balancing between the two. Or what about putting an ipso facto clause in there, that upon the insolvency of one of the banks, the agreement is terminated, and then you run into, are ipso facto clauses enforceable against FDIC? Would they be enforceable in bankruptcy? Do you run into these issues? So that's just a brief overview of all of these litigations. If you go out and look for participation agreements and litigation over the last few years, it's been on the upswing. And as long as the loan's paying off, this 2-page participation agreement covers what you need because the loan's paying, and no one's concerned about that. But when it stops paying, that's when people start looking at it. And would that document that's been around for 30 years requiring you to make your disclosures by telex, is that the document that you want to be relying on when you go into litigation with two banks who have the ability to extend the litigation for a long period of time? They're not going to, you're not going to wear down a borrower if the both sides are banks involved in this?
The next one is bank tying. And this is actually kind of an obscure, or I think it's kind of obscure. I haven't seen a case on this in quite a while, but one came up last year. And there is a provision of the Bank Holding Company Act that prohibits banks from tying, from offering products or services conditioned upon the purchase of a separate product or service. And in this particular case, the borrower claimed that the bank made a loan contingent on the borrower also buying some REO property that the bank was trying to get rid of. And the bank, the borrower sued the bank. This is an unusual kind of lender liability case. But the court found that this stated a claim. And the commitment letter in this particular case was pretty clear that the loan was contingent on the borrower purchasing this property from the bank. Now, there is an exception. It's okay to tie traditional banking products. So it's really unrelated products that you can't tie. Traditional, for example, you can tie revolving credit and term credit, things like that. But you can't tie, purchasing REO property and some other things. Sometimes it's difficult to determine what's a traditional bank product and what isn't, particularly as things evolve. But there is a Federal Reserve advisory opinion that you can look at that gives a lot of examples on that.
Good morning. My name is Chrissy Turner, and I'm here in Stites' Lexington office. I've got a couple cases to discuss with you. The first one is covered by the Fair Debt Collection Procedures Act that Katie Bell hit on this morning. And the FDCPA is remedial in purpose, and it is supposed to be interpreted very broadly by the courts to effectuate that purpose. So the courts have given a lot of leniency to the words and interpreted it very consumer friendly. There's also a strict liability component, which means that the debtor or the borrower doesn't have to show that damages existed, doesn't have to prove knowledge or intent. The debt collector is strictly liable for any violation. And the standard is also a very low standard to meet. It's the least sophisticated consumer, which is a pretty low standard, and it will always be construed against the collector. So the case I want to talk about first deals with charge-offs, and it came out of the U.S. District Court right here in Lexington. Stratton versus Portfolio Recovery Association. And it is a case where the original creditor had an interest rate in the contract with the debtor of 21.99%. So it was a credit card. And after a while, the lady stopped paying. The debt was charged off. The interest rate was charged off, and the debt was sold to a third-party collector, which was Portfolio. So Portfolio filed suit about 2 years after holding the debt, filed suit against Stratton, and wanted to do the contractual rate of 8% in determining what she owed and what its damages was. In Kentucky, the contractual rate of default is 8%. So Stratton sues the credit card company under the FDCPA, the collector under the FDCPA, saying no, the original holder of the debt charged off the debt. And the district court agreed. Well, she appealed that decision to the Sixth Circuit. And under the Sixth Circuit ruling, there was a violation by the under the FDCPA by that third-party debt collector. And the court said, we are not going to let the the assignee, which would be the third-party recovery company, we're not going to let you charge 8%. If you took a debt with the interest written off, that's the decision that you took when you accepted it, and we're not going to fix it for the creditor. So she is able to pursue her FDCPA claim against the third-party company. Now, what is interesting about this case is it has a long dissent by a lady named Judge Alice Batchelder. And she said, we can't turn everything you can think of under the FDCPA into a state law claim. This is getting out of hand. It's too broad. We should have never made this decision. And for those of you who are not familiar with an appellate panel, there are 3 judges, and it takes 2, so it goes with the majority. She was the only one that thought this was wrong, and so she wrote a lengthy dissent saying why she thought it was wrong. Unfortunately, Judge Batchelder has been on the bench for about 30 years, and so her time to leave the bench will be soon, and she's retiring. The person that wrote the opinion has just been on the bench about 10 years. She's only 61. She'll be there for a little while longer. She started out her opinion slamming debt buyers and spent a significant portion of the opinion talking about that it's a huge problem in the U.S. and that people are making too much money off of buying these debts. And so it was, when you start off an opinion like that, it perks up the ears of plaintiffs' attorneys who are looking for something, the next big thing to sue on. And so I agree with Katie and Brian. I do believe that the FDCPA will be the next hot point to be reworked, and that will be the next area that a lot of attorneys will be suing under because attorneys' fees are recoverable, and so the attorneys know if they press this and win, their fees are going to get paid. And while like a lady like Miss Stratton, she may receive $1,000 for the violation, but the attorney will get his or her fees paid in full, which makes it very lucrative for the attorney to keep going with the case. The second case I want to talk about deals with proofs of claim. When there is a bankruptcy and the creditor files a proof of claim with the bankruptcy court as to the debt. This case is out of the 11th Circuit, Crawford versus LVNV Funding. The third-party debt collector bought furniture company debt. The debt was very small. And this was it was like a $2,000 debt. So the debt buyer filed the proof of claim after the bankruptcy was filed. But this case took place in Alabama. And in Alabama, the holder of the debt had 3 years to sue if they were going to try to recover that debt. And those 3 years had passed. So the proof of claim dealt with an issue that if you tried to sue on it outside of bankruptcy, you couldn't collect it because it would be a violation of the statute of limitations. The debt collector had waited too long. And in this particular situation, it was a Chapter 13, and in Chapter 13 cases, it's up to the debtor to challenge the proof of claim. If not, the proof of claim will be good, and the debtor will have to pay a portion of it into her plan and designate certain funds to cover that debt. So the question that the court was facing was, is filing a proof of claim under these circumstances where the statute of limitations could not be enforced outside of bankruptcy, is this something unfair, unconscionable, deceiving, or misleading towards the least sophisticated consumer? Because even though a debtor in this instance was represented by an attorney, the standard was still the least sophisticated consumer. And the court concluded that filing a proof of claim where a debt cannot be collected outside of bankruptcy because the statute of limitations has expired, you can't file a proof of claim. That violates, if you file that proof of claim, you're going to violate the Fair Debt Collection Procedures Act because it creates a misleading perception that that debt is enforceable. Now, this past week, the Supreme Court decided that we're not going to hear this case. So this law stands. It's in the 11th Circuit, which is a little further south than us, but other courts outside of the 11th Circuit have reached this same conclusion. And ironically, this opinion also started out with the judge slamming debt buying and how horrible that this problem has become across the U.S. And so again, that's why I think that the FDCPA is going to be another hotbed for lawsuits, and lawsuits under the FDCPA are growing.
A case that the Supreme Court did take up and decided this year in January was on Truth in Lending Act and rescission under that act. And with rescission, with a refi, the borrower has the right within 3 days, an unconditional right to rescind the loan and walk away from it. If the lender does not provide the required disclosures, then there is a right within 3 years to rescind the loan. Before, and the Act provides how that you'll notify the creditor that you are rescinding the loan, and do that with the requirements of the board, which they're referring to the CFPB. And those regulations require a mail, a telegram, or other means of written communication to rescind the loan. And the issue that had been coming up was what they had to do to rescind the loan. What did the borrower have to do? And a circuit split had developed on whether or not it was just send a notice of rescission to the lender, or if you had to file suit within the 3-year statute of limitations. The facts in Jesenowski were that they originated the refinance on February 23rd of 2007, and on February 23rd, 2010, they sent their written notice. And that's the thing, under the regulations, the notice is effective when you send it by mail. It's not a matter of receipt of the notice by the bank, it's just the sending of the notice that affects the rescission. The bank that received the notice of rescission sent a response rejecting the notice of rescission on March 12th of 2010, and the Jesenowskis waited until February 24th, 2011 to file suit to have the rescission enacted, have the rescission effected. And that suit was dismissed on a motion to dismiss based on the 3-year statute of limitations, and went up on cert to the Supreme Court, and in a very long opinion by Justice Scalia of 5 pages, he made it very clear in the opinion of the court that rescission is effected upon notice, not just exercised. It is rescinded upon notice. The instant the borrower sends that notice of rescission, the mortgage is no more. And within 20 days, the lender has to take steps necessary to make that mortgage no longer a lien on the property. Needless to say, this decision has led to many more questions than answers. You've got issues with, what if, like this lender here, you disagree with the right to rescind? What do you need to do? Do you need to file suit within 20 days? Or can you just wait until the borrower does something about the fact that you've not released the mortgage on their property? And when do the borrowers have to take action? Do they borrow another statute of limitations? In the Truth in Lending Act, you have a 1-year statute of limitations to bring for a violation of other provisions of the Act. Do they have to bring the claim within 1 year? So in Jesenowski, they brought it on the 1 year and a day after the notice. Would that have been a violation? Would the statute of limitations be a defense for that side of it? That was not up before the court. They were just there on the whether you had to file a lawsuit or just send the notice. Other things that come up is the ability to tender. One of the things that had to be alleged in lawsuits was that I, the borrower, I want to rescind the loan, but I also have all the money to give back to the bank. I have the ability to tender the money back to the bank. It's unclear that you still have to include tender, the ability to tender in either this notice or in the lawsuit. You also have the issues come up with failure to release statutes. You look at Kentucky with their statute that says you have to release the mortgage within 30 days of notice, or you start running afoul of statutory penalties, $100 a day for the first 30 days, $500 a day after that for failing to release. And so is a rescission under TILA, under Truth in Lending, would that qualify as a event that causes a failure to release under Kentucky's statute on that? Then you look at the impact on RMBS loans. You have these with the reps and warranties about this loan being an enforceable mortgage, having an enforceable mortgage. Do you have to worry about violating the reps and warranties with the potential rescission out there? Do you have to buy back the loan? Or do you have to file a DEC action to have it determined whether it was a valid rescission? Another thing that can come up with is non-judicial foreclosure states. Can a borrower, if you're within the 3 years and you start a non-judicial foreclosure process, can they send off a notice of their rescission and make you have to take it into court at that point to resolve whether or not the lien's still valid and avoid potential issues with a wrongful foreclosure action? Another issue that comes up is the priority issues. And what if the borrower can't tender after they've rescinded? Well, how do you get your lien back on? And what if another lien, what if the borrower rescinds, goes out and borrows, gets another mortgage on the property that gets ahead of the one that you released because you had to do it within 20 days, but then they're not able to pay it back? Where do they put you in the line when you try to get your mortgage back on the property? In Kentucky, we've pretty much done away with equitable subrogation, so would we have that as an option to protect the lender faced with a rescission? So, as you can see, Jesinoski took 5 pages to explain that the statute was clear. All you need to do is send the notice of rescission. There's going to be many more pages and lots more questions on what this actually means for lenders.
This is a usury case, and it's a case about an emergency room debt that wasn't paid, and it was assigned to a debt collector. And like a lot of service contracts, it provided that if the debt is not paid on time, that the creditor is going to charge a 1.5% per month service charge. In this case, when the debt collector filed suit on it, the borrower filed a counterclaim saying, "Well, that's usury. It's not a service charge at all. It's you're charging interest at 1.5% per month, and that's exceeds the 8% limit of under the Kentucky usury statute." And Judge Hayburn agreed. And it's interesting to me because you see these contracts all the time in services by dentists or in car repairs, and tuition contracts and so forth. But the Western District found that the charge here is interest. It's clearly for the use of money. It's not a fee for services. And in this particular case, because the collector was a third-party debt collector rather than the creditor himself, it was also a violation of the Fair Debt Collection Practices Act.
In my opinion, this case wins for best name today in Ray Bushyhead. And it also wins for being the most offensive bankruptcy case that I've read in a long time. It involves a couple, the Bushyheads, and they decided to open a spa business. So they put down about $86,000 and took out a loan of about $400,000 from a bank. And the spa lost between $4,000 and $10,000 every single month it operated. That may be because the background of the Bushy Heads was in trucking. But they were running a spa, not very well. So they refinanced the debt as best they could and then decided to close the spa down, not practice anymore, go back into the trucking business. And that was very good for Mr. Bushyhead. He got a job that paid $350,000 a year. And the case language says money flew into the Bushy Case house and went out just as quickly. Bushyhead house. They bought Mercedes, they took trips, they bought jewelry, they had nice furniture. Then they filed bankruptcy. They filed a Chapter 7. And they didn't have a lot of assets because they had gone through the money. They didn't buy a house or buy anything that you could seize. They just decided to wash away the hundreds of thousands of dollars to the bank under a Chapter 7. So the bank was like, wait a minute, this isn't fair. And the U.S. trustee agreed. And the U.S. trustee said, we're going to dismiss your case for bad faith. And he was relying on a particular section of the code to do that. And he lost. The bankruptcy court said, there is no bad faith under this particular exception. We're only here because the Bushyheads have money to pay, and ability to pay is not a reason to kick you out of bankruptcy on this particular section. There are other sections to use, such as, are you hiding assets, which they did hide a little bit of assets, but eventually they turned them over to the trustee. They were hiding about $15,000 in cash in their bank account. So they turned that over. But ability to pay is not to be considered whether you're filing in bad faith. So the Bushyheads were able to dump all of this debt in Chapter 7, and the bank was just holding the bag. Now the U.S. trustee was very dissatisfied with this ruling and appealed to the next level to the district court. It's under review right now, and a decision has not been made because they're on the briefs. But so it may turn around. Now here is the bad thing if the decision stays. Because the bankruptcy court said there are other ways to kick these people out of bankruptcy, the other ways include expense for the bank, which is you file a non-dischargeability action, which means you take discovery and you either adjudicate the matter to the merits all the way through summary judgment or through a trial. And that means months of litigation and expense. So there's no, if the decision stands, the bank could be left holding the bag, and the only way to get to kick the borrowers, the debtors out of bankruptcy would be to go through a long, expensive process to get their discharge denied.
Back to me again. Two quick issues. I want to talk about evaluating property that you're extending loans regarding, and then enhancing the value of that property. This last thing, this is what's going to make you be the hero to your borrower. When you are confronted with making a loan, some of the things you commonly do for real property, I'm sure you do these two things. You do a title search and you have a phase 1, and if you have to, you have a phase 2 done. A lot of times that's sufficient. But I suggest that there are some times when that's not enough and you should go further. If you're looking at some facility in particular, that is, say, a manufacturing facility, something that's going to have environmental permitting, you often look at zoning. If I'm loaning for something, is it going to be operating in an area that's zoned properly, and those kinds of land issues. Those are things you always look at. But ask the questions about what kinds of environmental permits are they going to need. In particular, the water permits, the water discharge permits, and the air permits. If there's going to be a change in the use of the property, if this business that's being advanced is going to be a change in the operations and may require new permits, you need to look beyond that and ask, will they be able to get those permits and operate the business as it's planned? There are certain characteristics about watersheds that now put increased obligations on a permittee, someone getting a changed discharge permit. Maybe they have to make some kind of socioeconomic showing. They have to do this long, detailed study about what kind of impact it's going to have on the watershed. And the same thing for the air permitting as well. Also, you're very experienced in looking at financial statements, and you know how to track down the truth of are those numbers on the balance sheets, do they really say what they say they say? But if someone comes to you with assertions about the values of property, in particular natural resources properties, minerals, oil and gas, limestone, timber, ecosystem services, that you may be involved in something like a wetlands mitigation bank, saying, oh, we've got this wonderful pristine property in mountainous West Virginia, loan us the money so we can develop it. Well, look at things like the leases. Have somebody go do ground truthing, and are the materials really there that they say they are? We've seen some horrible cases, in particular some of the from the coal mining industry, where millions of dollars have been loaned on assets, and if someone had actually gone to the property, they would have seen that had been mined out 5 or 10 years earlier. There really wasn't anything there to do. So look, just beyond the mere statements on the paper. And then finally, in this aspect, look at other liabilities that may come along with that property. Now, this is particularly important if this is a company acquisition, not an asset purchase. If it's a stock purchase or a membership in an LLC, because the liabilities of that business track through to the successor. And if that business, again, is resource intensive or is hazardous material intensive, perhaps that business, perhaps the seller business, was involved in shipping out hazardous wastes, and people that they did good faith business with to properly dispose of their hazardous materials, it may have gone to a less than reputable hazardous waste landfill, and that business that you're loaning money on may be stuck with that same kind of circle of liability that we talked about a few minutes ago, and it comes up, whoops, that's a surprise to you, because that then jeopardizes the financial ability of that borrower to continue their business. So again, look at some of the historical aspects of their business. And then finally, again, this is one of the neatest developments that's happened in Kentucky in a while, and you as a lender can come out like the hero to your borrower. Your borrower comes to you with a deal. I want to buy this property, and we've done a phase 1, and there's reason to look for hazardous materials on there. So you do a phase 2, and you do some soil borings, and you take some groundwater samples, and golly, there's some contamination there. A lot of people would walk away from that, say, oh, don't want to loan money, or the terms of the loan would be too high. But Kentucky this started in 2012 with a statutory change. The regulations were finally adopted last year for the Kentucky Brownfields Development Program. This is something that the Environmental Protection Cabinet is very, very excited about. And what it involves is taking a piece of property with a known environmental condition. A buyer, your lender, that has done all appropriate inquiries, has done the phase 1, has identified those issues, has developed a property management plan to often either to do a small-scale remediation or to manage those contaminants on site in place without jeopardizing human health or the environment, and then to get departmental or the Division for Waste Management, to get the Waste Management sign off on that property management plan, and that buyer can then be assured that they won't be held responsible for any cleanup, for any characterization costs, for any of those kinds of nasties that happen under sort of Superfund liability, as long as they conduct their operations on the property according to that property management plan. So then if someone comes to you with problem property, you can say, oh, I've got a solution for you. We can go into the Kentucky Brownfields Development Program. We can make sure that your liability is well defined according to this property management plan, and then you can loan money on that property knowing that neither you nor the buyer are going to have some kind of horror jump up and bite them in the future.
This is a UCC case, Article 9 of the UCC on secured transactions. And as you know, we have a UCC filing system. We make a loan, you do a UCC search to see if there are other liens existing on the property you propose to take as collateral. Secret liens are bad things. Those are liens that are not required to be filed. And this case is started out being a case where the lower courts found a secret lien. It has to do with the public finance exception of 9109. 9109 excludes certain kinds of transactions from coverage under the UCC. And one of the exceptions is a transfer by government or governmental unit. And so the interpretation of that language was what was at issue in this case. This economic development agency provided financing to buy some big kind of equipment for a business in Franklin County. The finance agency did not file a UCC. It's not clear whether that was an error or they truly believed it wasn't covered, but they never filed a UCC. Delphi wanted to loan money to this business and did a UCC search and didn't see any liens, so they loaned a lot of money and they took an all assets lien on the property, on the property of the debtor. Well, the debtor went into default, and Delphi was going to claim that piece of equipment provided by the Economic Development Agency, but the agency claimed priority. It said, we're the government. This was a transfer by a government or governmental unit. We don't have to file a UCC. And COKI is an abbreviation for the Court of Appeals of Kentucky. COKI held the exception did apply to the government when it was a secured party. And so the result of that would be a secret lien in favor of governmental agencies providing financing. Fortunately, Skokie, the Supreme Court of Kentucky, reversed and held that that provision only applies to the government as debtor. And so when the government is a borrower, you know who you're dealing with. You know that the governmental entities have certain, they're different than other borrowers. They have certain characteristics that are different, and you can plan for that. So that's not a problem. So this is a good result from the Supreme Court that eliminates a potential secret lien that was going to cause us problems.
The Equal Credit Opportunity Act and a hot topic that's come up recently is the Spouse-Guarantor rule. The idea of the Equal Credit Opportunity Act is that you have a woman who's opening a juice stand in Florida, and the bank won't lend money without the husband guaranteeing the debt. She wants to borrow the money. She's the applicant, and they've created the ECOA would prevent this discrimination. The board, the Fed, promulgated a rule, the Spouse-Guarantor rule. It's now overseen by the CFPB, and that was that the applicant's spouse may serve, but the creditor can't require it to be the spouse serving. And this has come up in two recent cases, one out of the 8th Circuit and one out of the 6th Circuit. The facts of the cases are basically the same. You have a husband's company who borrows money from the bank. The bank looks at the husband and says, well, your company's okay but not quite creditworthy, we're going to require you to be a guarantor, and oh yeah, we're going to need your wife to also be a guarantor on it. And in both these cases, the wives who had nothing to do with the business challenged the guarantees. They argued that these were discrimination, that these violated the ECOA, and they were unenforceable. And the question hinged on the deference that the court would give to the regulation promulgated by the agency. And in Hawkins, they looked at it and they said that the statute was unambiguous. It was clear that guarantors were not covered by the statute. The statute only addresses applicants, and a guarantor, you're not applying for credit, you're just backstopping the credit, so you're not covered by the act. The regulation is an inappropriate extension of liability and is not an appropriate regulation, and we're going to hold that these guarantees are enforceable. The RRLBB acquisition, the Sixth Circuit case, the one that is more relevant to us in our areas, is the opposite. The spouses are applicants, are guarantors, are applicants. They are covered by the act. The rule is, it's an ambiguous statute. It's unclear whether or not the guarantors were covered by it, so this is an appropriate regulation. And the regulation says that the spouse cannot be an additional party, and so the spouse in the Sixth Circuit case was able to challenge the guarantor as an affirmative defense. Now, the lender in the Sixth Circuit did not appeal that decision. More than likely, the spouse did not have most of the assets, and so they were willing to rely just on the collateral securing it and the husband's guarantor. The wives in Hawkins who lost that decision, they petitioned for cert, and the Supreme Court has granted it. And they're going to be addressing the potential ambiguity in the statute and whether or not there should be deference to the CFPB. But this raises questions about the ways to protect your documents from attack in a later collection action. One of those things that can be done is a potential for a forbearance agreement. And in that forbearance agreement, have the guarantors sign a waiver of claims and have the spouses waive any potential claim under the ECOA and have their guarantees supported that way. Another good recent case that's come out after the Hawkins decision, the Richardson case mentioned there at the bottom, talks about the burden of proof and who is going to have the burden on these cases for showing that the guarantee was required by the bank. Is it the borrower? Is it the guarantor? Does the spouse have to show that, well, I was required, it was me and only me, and show that there wasn't another business reason, the idea that the spouses hold this property jointly and it's standard practice for lenders to get both spouses liable so that they'll be able to actually collect on the property. Yes?
And that you're right to my question, which was, in the two cases that were cited, was there any additional collateral that was jointly owned that was required to be a part of the loan obligation?
And in the Hawkins case, there was jointly owned collateral. They did not discuss the jointly owned collateral and the issue of whether or not how much the Miss Dixon in the Sixth Circuit case had. But that's usually the.
And that what I've seen in the past is that's usually the path. It's not that you're the spouse. It's that I want a guarantor of everyone who has an interest in the collateral that's being used to secure the loan.
Right, and the Moran decision that's mentioned on there, that one is one of the first where the Sixth Circuit dismissed it out of hand, but in Moran they discussed the fact you've got to have both spouses on here. You've got to be able to go toward jointly owned property And this is, there's a business justification other than their status as the spouse. But this will likely be a hot case that comes out sometime in the next year, and one we'll be able to talk about next year.